Hello, my name is Daniel Castro. I'm Vice President of the Information Technology and Innovation Foundation, or ITIF. I'd like to welcome you to today's webinar on the hidden toll of state privacy laws. Today, we're going to delve into the issue of the impact that a patchwork of state privacy laws will have on the US economy. As I think many of you know, there's a growing number of states that have passed privacy laws in recent years, including California, Colorado, and Virginia. Since 2018, 34 states have passed or introduced a total of 72 different data privacy bills, and we're expecting this trend to continue. So, barring any federal intervention, the United States faces this prospect of an increasingly complex regulatory landscape for data privacy in the years to come. This past week, ITIF released a report that showed the results of an econometric model of these costs. Our goal with this report was to get a sense of how much additional compliance costs, market inefficiencies, and other economic implications there would be created if we see this patchwork of state privacy laws emerge over the next 15 years, rather than a single federal law. And so our report concluded that a patchwork of 50 state privacy laws could impose total out-of-state costs of between $98 to $112 billion annually, that over a 10-year period, these out-of-state costs would exceed $1 trillion, and that finally, a patchwork of 50 state privacy laws could impose out-of-state costs on small businesses of between $20 to $23 billion annually. So obviously, these are really significant numbers, and our hope is that putting this model out there helps policymakers understand and pay attention to why it's so important that we get privacy legislation right in this country. So to delve into this topic today, we have a really fantastic set of panelists here. We have Carl Holzhauser, who's Senior Vice President for Operations and Strategic Initiatives at TechNet, Jennifer Huddleston, who's Policy Counsel at NetChoice, and Caleb Williamson, who's the State Public Policy Associate at ACT, the App Association. So first, thanks to all of you for being here today. Happy Data Privacy Week to everyone. Really happy we're here having this discussion. Caleb, I want to start off with you because you've really been looking at this at the state level. How have state legislators begun to start addressing consumer privacy issues? What's their motivation and what are they doing?
Absolutely. Thank you for the question and thank you for having me here. I'm excited to be here and happy Data Privacy Week, everyone. So on the state level, many legislators have begun to address privacy concerns by expressing a pressing need to provide additional safeguards to protect the personal data of consumers. And, when I've been monitoring some of these state hearings, some of the buzzwords that have been echoed by numerous legislators have fallen along the lines of, the purpose of these bills is to allow consumers to know exactly how their personal data is being collected, sold, shared, and for what purposes. And moreover, a lot of these legislators want to empower the consumers to give them the power to opt out of their request of data and to, request that their data be deleted. But while that's a well-meaning policy behind this legislation, what we're actually seeing is more confusion being created generally. So what do I mean by that? So we have over 15 states currently that have introduced legislation that deals with some form of data privacy. And while there are 15 states that are introducing this, there are over 30 bills that are collectively being considered by committees or in the process of being introduced. And the privacy bills that we're dealing with, they're not all falling under one umbrella. What we're seeing is there are comprehensive privacy data laws. There are bills related to specifically online privacy, bills related specifically to children's privacy, bills related to internet service providers, bills that directly and solely apply to biometrics. And we're also seeing bills that are focusing on data broker regulation. And so all of this to say that there has been a unified need amongst legislators to give consumers some additional protections and to allow them to understand what rights they have, but the methodology behind it in terms of creating some sort of legislation has proven to be problematic in the form of patchwork legislation being introduced. And so what we're seeing now is 15 states, no uniformity in terms of whether or not businesses, for instance, have the ability to a right to cure. So if they're found to be in violation, do they have the ability to actually jump in and fix that and rectify the situation? In other states, we're seeing some conflicting provisions in terms of whether or not individuals have the right to bring suit if they have been wronged, versus whether or not the AG has sole discretion. And so this is what we're dealing with on the state level. So ultimately, we're seeing a collective of well-meaning legislators who are choosing to implement legislation in their own way, and at the expense of consumers, but also at the expense of businesses as well.
Thanks, Caleb. Carl and Jennifer, I'd like to bring you in on this too. As you're seeing these state laws, being enacted as well as the ones that are being considered, what are your thoughts? What are you seeing as the motivations here? And what sectors are being most impacted by these laws? Carl, maybe we can start with you.
Well, the impact of the patchwork is still being understood. As we've discussed, since 2018, 34 states have either passed or introduced 72 privacy bills. 3 have been enacted. And so companies, small businesses, and consumers are still just getting used to what's currently out there. But this creates a chilling effect on our economy. It confuses small businesses and medium-sized businesses who want to comply but don't understand the different patchwork and how to comply. Often their compliance person is also the business owner, and who's also the janitor and the CFO and all in one. It also is very confusing for consumers. We're hearing a great example here in the DC area. If I get in my car right now and drive 10 minutes to Maryland or drive 10 minutes into Virginia, there's a different regime that is covering what's happening on my phone and what's happening with my data. That consumer confusion is exacerbated as the patchwork grows and more states pass this type of legislation. But it's not a surprise that states are doing that. 4 in 5 consumers say that we need more regulation of our data. Over 80% of Democrats and Republicans polled say they think that more should be done to regulate data. The public is unified, which is why we feel that it's really necessary that we pass a federal privacy law, preemptive, that allows one standard for all businesses and consumers to understand their responsibilities and to be able to innovate using one standard rather than a garage company that's trying to make it into be the next iconic company having to spend millions of dollars on compliance because of the patchwork. That's not what we want for our economy. That's not the way we've done innovation laws in the past, which is why TechNet is really encouraging a federal privacy law to come about. And Jennifer, I know you have lots to add here, so I'll pass to you.
Well, I was going to say, you covered a lot of the key points, Carl, and I think a lot of this comes out of a desire to respond to what some see as their constituents or voters' demands. When we've conducted polling on what are the top tech policy concerns, data privacy, data security, protecting children online tend to be those top elements. At the same time, though, where tech regulation ranks overall in terms of what the average constituent thinks Congress should be focused on, or what they think probably their local legislatures should be focused on as well, tends to be farther down the list behind a lot of the big issues facing Americans today, the economy, the COVID-19 pandemic. So putting those into perspective when policymakers are trying to determine what policies to focus on in a particular action. As Carl said, there really is a lot of a need for a federal data privacy standard, particularly as we continue to see more states consider these issues. We've got 2 very different models right now in the California model and the Virginia model. And as states continue to kind of pick up on these models, we're likely to see more deviations that could eventually raise issues where these state laws aren't compliant with one another, and then really force those small companies, those innovators, those apps into a tough decision about where to offer their product.
Thanks, Jennifer. I think your point about, some of these big laws, the big state laws, the California one, Virginia, Colorado, I think, it's really interesting to me because, these are one, big states, and two, they're really comprehensive laws. I wanted to put this out there to the panel. Maybe, Jennifer, we can start with you on this one. How are you seeing the proposals in these states that are, they're now going through, the enactment process? They're still, in some cases, trying to figure out exactly what the laws are going to mean in these states. But how are you seeing that shape the national conversation around what should be done? Are we all just going to copy California? How are you seeing the debate play out there?
Well, as I mentioned, I think we've had a couple of different models emerge now. You have a CCPA, now CPRA, after last year's ballot initiative, which would be the California model that is very restrictive, very regulatory. There's a lot of questions about what enforcement will look like. There's still a lot of questions about specific terms in the law. And then you have the Virginia model that, again, there still is a lot of concern about the impact of a state patchwork, but is significantly different from the California model in terms of what it's covered, how it interacts with some of the federal law, issues such as private right of action that I'm sure we'll talk about later in the panel. And so as we look at these states coming forward, in some cases we will see copycats of these two major laws, possibly with slight changes. So we've seen in the past a lot of state laws that were proposed closely resembled the California model. Now this session, we're likely to see probably more of a mix. At the same time, we've also seen, I think Washington State is on its third attempt at a state privacy bill this year. I can't remember if this is the third or fourth year the privacy bill has been run out there. And it tends to be, a little bit different than the California model, something that in the past has been more closely modeled after GDPR in Europe, which is, of course, another element when we're talking about the data privacy landscape. Is there's this question of, given the European law, given the impacts that we've seen there on American companies, but also just in general, what can we learn from that in moving forward with a potential federal policy standard?
Yeah, thanks, Jennifer. Caleb, I want to ask you, a similar question here. I mean, as you, kind of laid out, there's both these broad privacy laws and these kind of targeted ones, like the ones around biometrics or COVID data. To what extent do you think states are going to, replicate these directly? How much, when they replicate them, are they replicating them exactly, or are you seeing deviations in them? Can you talk a little bit about what you expect to see in a year or two ahead?
Yeah, sure. So on the state level, one thing that's been interesting is hearing and also engaging with some legislators who have actively consulted with bill sponsors from states that have successfully passed privacy legislation. That was something that did surprise a few people in the privacy space, primarily because oftentimes we recognize and we observe that most of the time people will look at a bill that's been enacted and say, okay, how can I tweak that to work for my state, but not necessarily engage and follow up with the bill sponsors on what have been the challenges and successes behind that piece of legislation. But looking forward, when we're talking about more narrow bills that focus on privacy, for instance, like BIPA, one of the things that we're starting to see now is more people coming forward and more industry leaders coming forward, talking about the harms that have been associated with particularly narrow legislation. In specific, and I know that we'll be addressing this a little bit later, but back to what Jennifer was talking about with the private right of action. And so for more narrower pieces of legislation on the state level, for instance, with BIPA and things of that sort, we're seeing a common inclusion of a private right of action, which is something that has historically been used as a tool to, in a way, harass businesses and create opportunities for frivolous claims, which oftentimes go back to what your report initially talks about as well, which is the increased cost that comes as a result of patchwork. And so when we're talking about the bills that are being introduced on the state level, one of the things that I foresee at the very least, is seeing more privacy laws that are going to align more with industry leaders in their positions. I think, for example, I can say this because I was monitoring the hearing today and also another hearing yesterday in two states, in Maryland and Indiana. In Maryland, the initial privacy bill was actually modeled after the GDPR, which was a European EU model. Upon testimony from industry leaders yesterday, that bill was ultimately decided to go back to redrafting to mirror it more so after Virginia. And so I think the future of what these state privacy bills are going to look like will greatly depend on the level of engagement by industry leaders. I think that when industry leaders come to the table and we can articulate the challenges and successes that are associated with particular bills and the impact that it has on both consumers, but also businesses, and finding that sweet spot, which Virginia's model seems to do. That is something that we ultimately, and I ultimately believe that will kind of stir a good pot and force more legislators to actually think twofold about these issues on the consumer side, but also on the business side as well.
Thanks, Caleb. It's always striking to me when I hear about policymakers that are modeling U.S. laws, around the GDPR, because one, we have years of evidence showing how the GDPR, has not led to increases in consumer trust, which was kind of the big thing that it was supposed to do. We have lots of evidence about, how it's raised costs for businesses, high compliance costs. There's been so many challenges with it. And two, the European model for data protection is just fundamentally different than the U.S. model, even in terms of enforcement. So the idea of replicating that in the U.S. just seems, like kind of, square peg, round hole approach. But then, the last part is when I hear states doing this, I mean, that to me is what's most surprising, because the entire point of the GDPR was to say that, Europe had all these member states with different privacy laws, and we needed to have one, cohesive privacy law in Europe. So that was the point of the GDPR, was to say that across all of the EU, we're going to have the same privacy rules. So to see all these different states start to do their own thing and say they're basing it off of the GDPR, it's just like they're missing the main point there. Carl, I want to turn to you because one of the things I thought was really interesting about the United for Privacy campaign that the TechNet launched is that you had all these local chambers of commerce also signing on. And I know you've also been, talking with small businesses. So I was wondering if you could just kind of talk about, what you're hearing from businesses in terms of the impact these laws have and what they're thinking about as states start approaching this.
So Daniel, first, thank you for giving me the ability to do a shameless plug for the United for Privacy campaign. So for years, Politico, politicians, industry, we've all tried hard to push for privacy legislation, and it has not occurred yet in Washington, D.C. TechNet believes this is a top issue that must be addressed. And so we have linked arms with industry, the industry partners of every industry, from the advertisers to the U.S. Chamber of Commerce and the Business Roundtable, the auto industry, et cetera, calling for a national privacy law. And we're not being prescriptive about what exactly that looks like, other than it needs to be preemptive. But the time for Congress to act is now. And for all throughout the spring, we're going to be talking about this to anyone that will listen. And we do have a website for that. It's called intheprivacypatchwork.com, if you'd like to look at what we're up to. The imperative starts at the local level, though, as Daniel rightly started out with. Over 80 chambers signed a letter with some DC-based trade associations about 2 weeks ago that went to Congress, letting them know that this was an urgent priority. Now, why would local chambers care about that? Let's go back to what we just talked about the litigation here. So a private right of action is really important to discuss. There's two parts of it. One is we all agree that where there's malfeasance and bad actors and consumers are harmed, there needs to be a mechanism with which to deal with that. And the legal framework is the right way to go about that. But a wide private right of action leads to something that we've seen with the California privacy law. Since 2000, when it was enacted, there have been nearly 200 lawsuits that have been brought against companies who do business in California digitally, but are located somewhere else and are mostly small businesses. Now imagine if you're a smaller startup that's in, let's call it Kansas, and your website reaches California, and here comes a lawyer that's suing you and says that there's malfeasance and that you need to be sued and there has to be a settlement. This is a chilling effect on innovation and on small businesses that shows you why a private right of action is too far. We need to get the balance right. And if you think about the cost burden, your report noted that in California, the law will cost $78 billion a year in added compliance costs. But 32 billion of that is going to be borne by California businesses. All the rest will be borne by companies outside of California. Now, who's going to pay for that? Consumers. Because as businesses incur those costs with inflation rising, with them trying to maintain their profitability and recover from COVID-19, they're going to pass that along to consumers. So are we really helping consumers as we intended to with that type of regulation? TechNet argues that that removing the private right of action or having a limited one that has qualifications to get there is the right approach with a federal response that will reduce that cost burden. And I like to put that number just in context a little bit. Congress right now is hard at work trying to pass a bill to get our semiconductor chips launched in the US, get our domestic supply chain going so that we're not relying on other countries for chips. They're talking about 51 billion over a number of years of investment. Right? This is 78 billion for 1 year to comply with California, which nearly half of is going to be borne by people outside of California and small businesses outside of that state. So that's what we're seeing for now. Daniel, back to you.
Thanks. And Caleb, thanks for that, Carl. I mean, Carl brings up a lot of great points here. And this out-of-state cost is, I think, something that's really, been overlooked. When people see California or, Colorado, these states, passing these laws, they assume, oh, well, maybe that's bad for California businesses, but they're not realizing the big impact that it has on them. ACT, of course, represents, a lot of app developers and app makers all over the country who are, oftentimes those small businesses who are, selling, in multiple states. I wanted to ask, as we kind of think about the implications of a patchwork of state privacy laws for businesses and consumers, what do you see as the primary challenges there? How will they, deal with you think of a 2 or 3, maybe even a 10-person app development team. How are they keeping track of all the different state privacy laws that are out there and how they comply with them?
Right, and thank you for this question. To be very frank, fortunately, all of our member companies get the benefit of having me with the App Association being a point person for them. But even that poses some challenges. And so when we're thinking about, how are they staying up to date with compliance, this goes back to what we're talking about when we're thinking about what the cost will be for small businesses to operate and remain relevant and to remain effective and innovative with a state patchwork. And that's why we are firmly in full support of unified federal privacy legislation. And so for instance, what are we talking about? Like, what are some of these costs that our member companies may have to incur if there is no uniform federal privacy and there's just a patchwork that they have to, learn to navigate with? So for instance, they may now need to have a lawyer on retainer just to help explain the requirements of some of these bills in different states. They may need a vendor to perform inventory on the data that they do collect, seeing how that aligns with various states. We're gonna, the sky is the limit for all of the things that they will need to accompany and need to pay for. But some of them, honestly, it falls into kind of creating an additional hurdle for them to do business. So for instance, if they need to now have a firm on retainer, or let's say in a state that does have a PRA, private right of action provision, smaller companies could be a frivolous lawsuit away from having to either downsize or even end the work that they're doing. So when we're talking about the cost that our smaller companies will have to incur, and especially when we're talking about very small and independent developers and even members that deal with B2B, building software, building data sets that they then give to other larger companies, not selling data, but building models. That the cost is astronomically high, and the risk of them being able to focus all of their time on creating more innovative technologies is going to be diminished because their teams and their staffers will have to either be shrunk, or some sort of angel investor will have to jump in to really help them offset the cost.
And I think when we think about these costs, we also have to think about the fact that particularly for smaller companies, but for companies of all sizes, there's a limited amount of talent, there's a limited amount of resources available in any one company at any given time. So if the talent is having to focus on compliance, what innovative, potentially better alternatives might we be missing out in the meantime? Because rather than looking at ways to make the product better, or perhaps even looking at innovative security and privacy approaches, they may be having to focus on complying with a patchwork of different state laws as they expand and offer their products elsewhere. Secondly, to take us back for just a second to when we were talking about Illinois and the more specific law involving biometrics, this actually provides a really good example of the way that consumers often bear the cost, not just necessarily in monetary costs, but in terms of products being available. So there are numerous products and features that are often not available in Illinois. These range from fun things like the Google Art selfie match, if you remember that craze from a few years ago, where you could take a picture and it would run it through an algorithm and it would show you what your fine art twin was and what percentage and everything, wasn't available in Illinois. It also, though, can apply to a lot more security features. For example, Nest cameras can't do the friends and family matching that could allow an individual to have that additional element of security because of this law. And even things that just increase the convenience for many of us of being able to, say, upload pictures to Shutterfly and sort those pictures where we know that these are all my pictures with my family, these are all my pictures with my best friend, through photo tagging, isn't available. Now, as these technologies move on to new and exciting innovations, things that are making our lives better in many cases, I think there's the question of if the impact of these regulations is going to be that in some places you don't have access to that newest technology, and what does that mean?
Yeah, Jennifer, I think that's a really great point, because we often think about just the impact on businesses in terms of cost, but there's also this huge impact on consumers. I just want to open up that point as well, if anyone else wants to jump in on that. How are we seeing consumers impacted by a patchwork of state privacy laws? Carl, you talked a little bit about this kind of complexity. I just wanted to see if anyone else wants to weigh in on this point.
Well, I'll add a further thought on this of, we've seen what a 50-state patchwork can play out like in the data breach notification framework. We unfortunately never got a federal data breach standard. Instead, we eventually got to this weird patchwork where every state has something, but they all look a little different. And the result at times can also be some confusion, not only for companies, but for consumers as well, about what their rights are, when they should be notified, why, if I live in Virginia, did I get a notice, but my friend didn't? Does that mean their data wasn't involved? So I think that, when we're looking at broader topics in data privacy, this is going to evolve even more. And we really need to take that into account too, for when we're discussing the need for a federal privacy standard.
And if I can jump in really quickly, one thing that's also unique, while we're here talking, we are also consumers, right? And so when we're like, for instance, one of the things that dawned on me over time was just the amount of travel I do and where I go, and understanding and trying to figure out well, if I go to an event in Texas and stay at a particular hotel and then start seeing targeted ads about that one hotel I stayed one night in, part of me is, as a consumer, I'm like, well, okay, well, I know what rights I have here, in the state that I reside, even though I'm in Washington, D.C., that's an argument for another day. But when we're thinking about the different states, and for a consumer, knowing exactly what rights do I have, what rights don't I have, and how that all changes, that creates a ball of confusion within the minds of consumers as well. And that's just something I just wanted to throw in there.
Yeah, that's a great point. I want to ask, and I'll open this up, so whoever wants to respond, just go to you. I guess I want to play devil's advocate here, because I've heard some of the responses that often come back to the idea of a patchwork. One being, isn't this just the laboratory of democracy at work? Isn't this what we want to see? States experimenting with all sorts of different laws. Who cares if they're all different? But and then the other argument I often hear is, won't businesses just go with the most strict laws? So does it really matter if there's 50 state laws? Because there's this assumption that you can just there's one setting a business can take that will just cover all the laws. And I wanted to put both of those out there and see what kind of responses you have. And again, I'll just open this up.
So to kind of start with the last element there, I think that's oftentimes a confusion about how particularly data privacy laws work, because you can have one state could develop an opt-in system, one state could develop an opt-out system. It doesn't matter whose is technically more strenuous of a law or has more things to comply with. You can't create a product that's both opt-in and opt-out at the same time. So the app developers are going to have two different products in that case. And there are other elements in data privacy that are similar, where it can't just be you comply with the most stringent requirements. In some cases, it's instead these two requirements don't mesh whatsoever, and you have to decide where your product is going to be available, or which one you're going to comply with. When it comes to the laboratories of democracy argument, I think it's important to remember that data is a hard enough issue to deal with when we have different international laws, let alone when we start getting down to that state and local level. So much when we're talking about data privacy, when we're talking about these interactions, naturally cross state lines. And that's one of the great benefits of our connected age. But as a result, it means that this really is an interstate issue. This is not an intrastate issue that can really be defined just to a state's borders, where maybe laboratories of democracy could make more sense. So when we're talking about tech policy issues, we really need to look at what that appropriate level of regulation is. And because of the fact that data is going to travel across borders, if I'm sitting here in Washington, D.C., and my friend's in Alabama, and there's, a data center in Montana, whose law applies to that particular interaction are the type of hard questions that are going to get asked if we have a state privacy patchwork instead of a federal framework.
If I could just dive in here, if you think about consumers and their data, it's really clear that consumers, and I speak for myself included, want control and want certainty about what's being done with their data. As data is turned into, the new oil rush, and everyone wants it. It's all about the data, right? That brings up new questions like who owns it, who regulates it, who's in control of it. We've had these debates on many other topics over the years, including in the healthcare space, which led to the HIPAA laws, GLBA for banks. Can you imagine if we had a different system for controlling your privacy around banking systems in a state-by-state patchwork? This is a new frontier that didn't exist 20 years ago, but now it does. And so, I think that the consumer needs to be at the heart of this discussion, because it shouldn't be difficult for a consumer to understand, based on where they are, what rights they have, what responsibilities entities, including companies, have to protect their data, and what rights they have if things go afoul. And that confusion, bubbles up in terms of little fights about different things like private right of action or preemption, if you're talking about the federal level. But the water is above our head, guys. With all the data that's out there, we've got to have a way that consumers can feel certain about their data. And the added benefit is that businesses, particularly small and medium-sized businesses that have trouble complying with this, will have one way that they know that if they follow that they can be assured that they're doing the right things to protect data. So I'll conclude with, it really is all about the data. That's been the heart of this entire discussion. And for 20 years, we've been talking about this. The states are not waiting anymore because the federal government's not done what they need to do, which is why we're calling on Congress to pass federal preemptive privacy legislation to protect consumers and small businesses. That doesn't mean to undermine the states. They're certainly doing what their voters want them to do. But this is a great place for the federal government to step in, to echo Jennifer's point, for an intra-national issue.
Yeah, and I'll just piggyback, and I won't beat a dead horse at this point, but I will say that whenever we're talking about innovation, data, or technology, my colleagues on this panel are correct. It transcends state lines, and it emphasizes even more the need for federal preemptive privacy legislation. And I can't yell it loud enough, but this is a dire need for small and medium-sized businesses, but also for consumers generally. It benefits all parties when we get something done on the federal level.
So that's a perfect transition to what I want to talk about next, which is the state of comprehensive federal privacy legislation and what Congress can and should be doing in this space. Before I get into those questions, I just want to flag for our viewers that we are encouraging your questions. I've seen a few come in already. If you're watching our website, there's a little, if you scroll down under the video, you'll see an opportunity to enter your questions. If you're watching on YouTube or Facebook, there's a link in the description to Slido, and you can enter the questions there. And we'll be transitioning to those in a few minutes. But I do want to focus now on kind of what comes next. And to start with, Jennifer, you mentioned some of the polling that NetChoice did at the outset. I want to ask if you can kind of dig into that a little bit more. I found it really interesting. It's up on the NetChoice website. If you haven't, anyone watching wants to go into the details. But this to me is really interesting. We've seen so many hearings around antitrust, but that's maybe not top of mind for the average voter. Can you tell us a little bit about what your polling found?
Right. And we just saw another big antitrust hearing last week. But what our latest national polling showed was that only 1% said regulating the tech industry is the biggest issue facing the country right now. Instead, 26% said the economy and inflation, and 28% said the COVID-19 pandemic. But even with that 1%, when you really look into what do they think is the biggest issue facing Americans when it comes to tech policy, it does tend to be those data privacy, data security, protecting children online type of elements, not the antitrust discussion that we're often seeing going on. Additionally, some of the interesting things that came up were when you asked voters about regulating tech or trusting Congress to regulate tech, 56% said that they don't trust Congress to regulate online services in a way that improves those services, and that 72% thought that politicians should really be focused on other issues right now. But I think when it comes to those tech policy priorities, what we can really take away from this is that the priority for voters isn't about breaking up big tech, but is instead about these data privacy and security concerns. I also think there are some really interesting questions to ask about the way that some of these conversations, both some of the privacy and security concerns in some of the antitrust bills could play out, as well as questions about how regulations could potentially raise further concerns about who can and can't comply with them.
Carl, I want to ask you to weigh in on this too. What's this relationship between, antitrust and privacy? Is this something where, Congress can find bipartisan consensus?
I think that the antitrust hearing last week, or markup actually, and the related conversations about techlash and big tech and, how big is big tech getting, is a perfect entry point for the discussion about the need for a national privacy law. These big companies have a lot of the data that we're talking about, and while the law will benefit small and mid-sized businesses, considerably, this will also give consumers assurances that these large companies are being responsible with their data in a way that they're comfortable with. The antitrust markup last week did air some interesting things, even though that passed. You can tell that there's a lot of disagreement about how we're regulating in this space. And even this is a bill by Senator Klobuchar and Senator Grassley. And even from both of their parties, there was dissent at the hearing. For example, Senator Cornyn raised that he was concerned that this bill would be a big gift to the Chinese Communist Party. Senator Patrick Leahy said that he was concerned that there would be unintended consequences for small businesses. Senator Padilla openly opined at whether or not this provided the consumer impact that was desired. This is wading into a really new issue with thinking about upending our antitrust laws and undoing the consumer welfare standard, which has been used for many years. Instead, just target 5 companies that are perceived to be bad actors. I think that the fervor that went into that hearing, which though led to the vote to pass it out and has been fueling the debate to have this markup, is because of the same polling data that you've been hearing, with 4 out of 5 consumers saying, "What's the federal government doing about this?" That's becoming inextricably connected, where data and big tech are connected, even though data is in and out of all of our companies, be it a one-person company all the way to the biggest. So this is part of the United for Privacy campaign effort, is to showcase the fact that one thing that we can do, that we've been talking about for 20 years, is pass federal preemptive privacy legislation, which will get right at the heart of that issue that consumers are frustrated about and are telling their lawmakers about. So we would call on the lawmakers of that committee and all to look at privacy legislation as a great way to get out that issue in a way that I think we could get it done in a bipartisan way.
It's a great point, because I think what's striking to a lot of people that watched that markup last week is it passed out of committee without a hearing on the issue, versus it seems to be moving in this kind of fast track right now, whereas you've had privacy legislation where there's been so many hours spent on drafting and redrafting and finding consensus, and we were ready to see the legislation move, yet that's the one that seems to be moving slower. Caleb, I want to bring you in on this too. I mean, I think, again, kind of the question I have now for you and for the rest of the panel is, what do you see as the status right now in Congress of this kind of comprehensive federal privacy legislation? What do you think the roadblocks are going to be to actually getting agreement and moving forward on this?
Yeah, thank you for this. I think that one of the roadblocks will be it is currently this dividing line that people have that seems to say you can either be pro-business dealing with privacy or pro-consumer, and that you can't do both. And you can do both. You can have something that is very thoughtful, that will basically take the onus off of small and medium-sized businesses to comply with something federal. But at the same time, you can afford the consumers across the country with the rights that you want them to have. There is a healthy medium line. There's a line that we can toe. There is a line that it's not a hard line. It's something that is very fluid, that we can easily appease both sides. And I think that when we start looking at it through a partisan angle on the federal side, I think that's a big holdup. But on the state side, one thing that's very interesting to note is that we are seeing legislators from different political sides of the spectrum introducing comprehensive privacy laws. So this is a need that legislators on the state level across party lines are saying, yes, this is something that needs to be done. And when we're looking at the bills being introduced by legislators who fall either on the left or the right or somewhere in the middle, we're not seeing extremely polarized introductions. So we're not seeing solely one party saying you need to have a PRA. We're not seeing that. And that's something that is very interesting. And hopefully that's something that can, speak to the people of Congress, our Congress people, letting them know that, hey, this is a uniform and a universal issue that needs to be addressed. Now bring the industry leaders to the table, bring the consumer groups to the table, and let's get something done. However, whatever we do get done, we want there to definitely be a preemptive model in place. And I know later on, probably in the next 10 minutes or so, we'll probably, well, I know I'll probably end, but some of the things that I hope when Congress does pass federal preemptive privacy legislation, what they do include and what they don't include. But for now, I know that, the roadblocks seem to be more so along the lines of partisan, but also business versus consumer. And there is a way that you can appease both.
If I could jump in here, I think one other thing to point out is we often think of data privacy as a tech policy issue, right? All of us work on tech-related issues, whether it's privacy or other things, but it's much broader than that when you look at a lot of these proposals, both at a federal level, as well as some of the state models that we've seen, like California. These aren't just impacting the tech industry, because one of the benefits of data is that it's revolutionizing so many different areas of our lives. So as a result, in some cases, these data privacy bills impact everything from restaurants and florists to grocery store chains to social media companies. And so we really have to think carefully about all of those impacts and how all those different scenarios may play out, and the unintended consequences in some of these potential industries as we're looking at these bills.
Which is why it's a local issue that 80 chambers of commerce, local chambers, who are their members? Businesses in their communities who pay dues to their local chamber, sent a letter to Congress asking for this. This is a local issue, despite the fact that most of us that are on this Zoom are in DC-based trade associations. This is very much a local issue. And encouraging everyone watching and everyone who's participating in the call to action to think of ways that you can have a local voice with your member of Congress to share the urgent need for this. That's a very productive way to help move this debate forward.
So I want to ask one last question before we turn to the audience questions. We have a great set coming in, and keep them coming. I'll make this a two-part, and you can answer whichever part you want. Maybe we can do Caleb, Jennifer, then Carl on this. What key provisions would you like to see in federal privacy legislation, and what advice do you have for the congressional leaders working on this issue? How would you like to see them put a win up on the board, as they're going into the midterms? And what is your message to state legislators?
Sure. So for state legislators, because that's my bread and butter that puts food on my table, I would urge them to communicate with other legislators, primarily the sponsors of the Virginia model. While we want and we desperately need, and our member companies have screamed this from the rooftops, there needs to be something done federally. We need more state legislators to actively look at the legislation and the model that has come out of Virginia that seems to be the primary model that balances consumer rights, but also and it takes into account industry leaders' concerns as well. But on the federal side, some of the provisions or some of the things that we would love to see and that we recommend having is, you need to have preemption. For the sake of uniformity, you need to have preemption. We need reasonable control. So we want the law should require companies to communicate in a reasonable manner, to communicate exactly how they're processing the activities of users in a reasonable manner. We want to see a bill that includes a requirement to protect data from unauthorized access, and requirements that should be scalable depending on the size, scope, and complexity of enterprise. And things that we definitely do not want to see. We do not want to see a private right of action with no guardrails. We recognize, and we've seen on the state level through different bills such as BIPA, how a private right of action can be used to harass businesses, but also how that can be used to create some financial damages to small and medium-sized businesses that may force a business to fold. And so that's where I'll leave it now. But please look at our website, actonline.org. We have a Antitrust and Privacy white paper. We have other resources available as well if you would like to know more about the impacts that this would have on small businesses like many of our members.
Thanks, Caleb. Jennifer?
I think Caleb, hit many great points. One of the advantages of the approach to privacy in the United States has been that it's been a very harms-based approach. It's been an approach that allows new innovative uses of data to emerge while still providing a form of redress currently through the FTC, and also establishing those specific areas where things are more sensitive. So ideally, a federal privacy law should build on the good things in the US approach to data privacy that have allowed us to be a real leader in innovation and in information technology. With that in mind, though, given the current state of state laws, we certainly need to see a federal framework that does not that overcomes that patchwork barrier that's going on. One of my favorite quotes actually comes from one of Caleb's colleagues, Morgan Reed, who in a hearing once said, if state laws are a floor, then the floor is lava for small businesses. And I think we have to realize that's why a federal standard is needed. In terms of what not to see, I think that, we can certainly be a lot of the concerns that were already raised about what the kind of Illinois BIPA model type of private right of action could do to an influx of litigation, but also very carefully considering some of the trade-offs that may be involved in privacy. While we certainly all are very concerned about privacy, these can also come into conflict not only with concerns about innovation, but also with concerns about things such as speech rights.
And from TechNet's perspective, the ideal law recognizes the Federal Trade Commission as the correct regulator for this area. They have the expertise and the track record having done that. They also need to ensure that the Federal Trade Commission has the resources that they need to take this on. We've seen some action on that, but more is needed. There also needs to be resources for training. Small and medium-sized businesses, particularly ones in diverse areas, rural areas, minority-owned businesses, bear a lot of the burden of this because it's just harder for them to comply because of their size or location. So the resources at the Small Business Administration, Department of Commerce, and Federal Trade Commission to help both consumers and small businesses navigate this is very, very important. We also agree that a private right of action should be avoided in this, or should be very, very narrow so that it doesn't have this chilling effect and add a lot of cost to the system. We think that there should be a recognition that technology evolves and that we shouldn't have floor setting. The government's too slow at the way it produces, legislation and regulation. We need to move with the speed of innovation, and so that the laws can be adapted as we grow. As we mentioned before, I didn't have a Facebook page till the mid 2000s, didn't have Instagram till 2012, and now it's a big part of our life. That type of evolution is going to continue to occur. I mean, look at TikTok. It didn't exist until 2016, and now look at the number of users that it has. So we need to have flexible and agile regulations and laws that give our lawmakers and regulators the ability to address issues as they come up and as innovation occurs.
Carl, I don't know if that was a plug to follow your Instagram, but I'm sure you'll have some new followers now. So we have great questions coming in. I want to get to as many of them as possible. I'll try and direct these to people, but if anyone wants to weigh in on the panel, please do. Caleb, maybe this first one could be for you. A question came in: do any of the privacy bills have self-evaluations designed? So how do legislators know if they've done their job well? Can consumer experience be a criteria?
I think consumer experience could be a criteria, but for now, from what I'm understanding from the question, it seems that in terms of relating to these bills, at least, legislators won't really know if they did a good job until after these bills have been enacted and been in focus for a year, and so in terms of assessing their success on this particular issue, I hate saying this phrase, but time will tell, and that's basically where we are right now. Oh, I can't hear you.
Thank you so much. I knew one of us was going to do it, and I drew the straw there. Jennifer, to you, would an omnibus Federal Privacy Act need to revise very limited federal laws, such as the Gramm-Leach-Bliley Act, opt-out notice for sharing with non-affiliated affiliates or non-affiliated entities?
I think that actually raises a really good point, which is any federal data privacy legislation needs to consider how it will interact with existing federal data privacy laws. Gramm-Leach-Bliley was mentioned in this question, but we also have laws such as COPPA, FERPA, several other data privacy related laws that are currently in play, and there needs to be clarity on how those laws interact so that the regulated industries and individuals understand what regulations they're subject to. And again, particularly thinking of, as Carl mentioned, how quickly new technologies can emerge. Even when subject to these regulations, we want to make sure that companies are aware of how to work with the processes around those particularly sensitive information that is already subject to some of these existing laws.
Carl, to you, how does the patchwork of privacy laws affect cybersecurity at businesses, both small and large?
Well, the two are directly related, and it's important that we consider the cybersecurity controls in all legislation now, because the market is very good for bad actors who are trying to get into our systems. That's why they're doing it. There's a lot of incentive for them to do that, but it's a lot harder for a smaller, medium-sized business to be sure that they're doing the right things to comply with a regime that will both protect them from litigation, but also help them control their systems and protect the data within it. I go back to, it's all about the data. There's not enough regulation in the space. If you relate it to the banks or to HIPAA, two things have been mentioned here. When we wrote laws that had to do with our banking system and our finances and our personal information that went into that a world didn't exist where that same information is all over the internet, right? It's stored on servers at many businesses, which is part of the confusion. And so to have cyber built into it and have the two as one means that not only does the small business know what they have to do to comply with a privacy regime that protects the data, but also they know that they've properly secured the data so that a bad actor can't get into their system, steal the data, and then the protection is moot at that point. So TechNet very much feels that the two issues are related, and that lawmakers, both at the state level, Caleb, which I've seen happen a lot, and at the federal level, cyber should be in the discussion all the way through, and built-in protections and incentives for complying with cyber regimes.
Thanks, Carl. Caleb, to you, I think maybe we have time for two more quick ones. One is, what's the trend for states working on privacy legislation for including the term geolocation in their efforts, and how are they defining geolocation? Are you seeing that much?
Sure. So for the states that are engaging with it, one of the things that is also a problem with the patchwork legislation that we're seeing, the patchwork of privacy laws, is the conflicting definitions. You rarely find, or I've at least rarely seen, uniform definitions that have been laid out in these legislations. But as it pertains to geolocation services and tracking, I haven't seen too many bills that have articulably defined that term very well. And for most of them, unless you're looking at a very narrow piece of legislation, I haven't really come across too many bills indicating anything about geolocation.
And the last one that we'll get to is, any thoughts on the Uniform Law Commission's Uniform Personal Data Protection Act for any states that haven't enacted omnibus privacy laws?
Well, I can say full-heartedly that it is arguably one of the most problematic pieces of privacy legislation that's out there, and it has been criticized heavily by both consumer groups and industry leaders. So there is, if you have it, look to Virginia or just get rid of it altogether, because it is truly a mess.
Great. Well, I know there's always more we could cover, but I think we did cover a lot of ground. I want to thank all of you who are watching for your participation today. I want to thank our panelists for joining us and sharing your insights. Again, I encourage you to check out all of our websites. We have some great resources, including this new report we put out this week on itif.org. So thanks again for joining us.